First, with regard to the ruling on the motions for directed verdict. So both the state and the defense requested and have gotten a trial in this case before a jury. Is not before the court as a bench trial. So that means that this court is not the trier of fact. And the standard, as you all know, for a motion for directed verdict is not the beyond a reasonable doubt standard, that what the jury is going to be determining the facts on when the case is given to them. The standard at the stage of motion for directed verdict is that all of the evidence is to be viewed in the light that is most favorable to the prosecution, and doing it in that way, looking at it in that way, is there any evidence from which a rational trier of fact could find the essential elements of the crimes that are charged. So with regard to the motion for directed verdict on counts 1, 2, I'm trying to do these in order. Now, let me just do it this way. I am denying the motion for directed verdict on all counts except I am granting a motion for directed verdict as to count 59, count 60, and count 62. I do not believe that the elements of, that even viewing in the light most favorable to the prosecution, there's evidence upon which a rational trier of fact could find the essential elements of possession of those particular items. And let me say that with regard to counts 1, I'm sorry, not count 1, counts 2 and 49, again, is not a beyond a reasonable doubt standard that the court is required to employ in determining a directed verdict as to those counts. I understand the arguments, but it is up to the jury to determine credibility of witnesses, and it's up to the jury to determine what witnesses or what parts of testimony they might believe and what witnesses or parts of testimony they might not believe. So if there is evidence presented that a jury chooses to believe, which is how I have to take it, proposed RICO instructions, but have you sent yet the crimes that are just set forth in the overt acts?
The pattern instructions, Your Honor?
Yeah.
Yes.
Okay, maybe we just missed that.
I titled it, Your Honor, proposed, I think, supplemental jury instructions.
All right, well, Ms. Persfield will look for that. I know there are a couple of things we need to circle back on the non-RICO part of the jury instructions, but let's do the RICO part first, if you don't mind. And I keep further editing my proposed RICO jury instructions, so y'all have the latest, I'm not going to say greatest because it may not be, but the latest version of what the court is thinking about charging. So if we want to open that up and kind of start there, and then I'll listen to whatever anybody wants to suggest should be in or out or said differently. Now, Mr. Atkins, I wasn't quite sure I understood your teal. I didn't know if you were saying, oh, the court struck through these and we think they should be included, or what exactly the teal comments were.
Your Honor, the teal, I tried to capture either items the state believed should come out,
all right,
or words that the state had.
Okay, so we maybe just, as we walk through, you just bring them up to me as we get there. All right, so if we want to all get to that document.
Mr. Floyd is going to take the lead on this part.
And, Your Honor, since you just emailed us, is it all right if I remain seated because then I can see
That's fine.
the screen? And are we going to go through what the state email to you first, or are we going to go through what you just?
What we're going to go through is what I am proposing, and then to the extent that y'all want to add or subtract or modify, y'all tell me. So I can open up as well. I've got multiple screens up here. The state's latest proposals as they modified them, and then the defenses as well. I think those are the same as they were a couple of days ago.
Okay. Well, Your Honor, since we had submitted those, I can go through those and explain what our thinking was.
Okay.
And the first one is, I'm going off of.
Let me find it first, if you don't
Excuse me,
mind.
Mr. Floyd, which document are you referring to?
I think it's something Mr. Atkins sent us. Is that right? Last
Oh,
okay.
last night.
One we said last night, yes.
Can you give me just?
Yeah.
It's called Jury Instructions RICO Draft is what the reline for the email is. And then it's got an attachment.
Thank you.
Mr. Weinstein, do you have it?
I have it.
Okay, I didn't want to.
No, thank you.
I think there's another one.
No, that's not RICO, that's the one
I'm assuming the one you're referring to is the one. It came around 8:20 last night.
No, that's a different one.
Oh my gosh.
We're talking about, no.
Which one? Are,
There's 3 documents. The court's version of the RICO charges, the one that Mr. Atkins sent last night, that was no. Sorry. That was the jury instructions RICO draft for Mr. Atkins. And then there's also, more recently from Mr. Atkins, the additional instructions that relate to some of the overt acts.
That's correct, Mr. President.
Okay. All right.
And so, as I understand it, we're going to talk about the state's RICO instructions that Mr. Atkins sent last night.
Sure.
at approximately 8:20, that's the one? Okay, thank you.
That sounds about, that time sounds right. It certainly felt like about 8:20.
I felt like midnight.
And it's got yellow and red and teal and it's multicolored. That's
It's,
the one.
it's, it's, it's a potpourri, Your Honor. Most of these, despite the color variations, it's pretty simple, I think. The first one that the state proposed some changes to state RICO conspiracy, and I noted that the court had said needs to be tailored to indictment language. I took that.
That was really early on.
Okay, well, but I think it was correct too, because what was there prior to any modification is just a recitation of the statutory language or something very, very close to it.
All right.
I
So if you would do me a favor and looking at the state's proposal, do you feel like that captures everything that needs to get captured?
I think it does.
Okay.
And what we were looking to do is just remove language that is in the statute.
Right.
But does not
Agreed.
apply to this case as it's been charged and presented.
Okay, so,
It just simplifies it. That's
yeah, so I mean, what I'm proposing is the state must prove that the defendant, and then list out the elements, knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the conspirators committed an overt act to further a criminal objective of the conspiracy. So I think that gets rid of all of what was not applicable from the statutory language.
I think that's correct, Your Honor.
Okay. And then, a similar thing for the subsection B.
Yeah, the only, we've been using the word tweak. In the language that tracks subsection A,
Yeah,
3, personal property, money or other personal property, this may just be semantic. I think the statute actually says personal property including money, which includes money, but this starts with money. The statute starts with personal property. It encompasses money. It's not a big deal.
yes. Money is personal property, which is why it says money or other personal property.
enough.
Okay.
And as to the elements of B, yes, I think you captured that as well.
Okay,
Your Honor,
yes,
regarding this, I just had one issue as well. I didn't know
sure.
before we moved on, are you done with?
I'm done with this, John.
Okay. Your Honor, I would ask on number 6
Yep.
of the elements,
Mm-hmm.
since, well, I don't know, I haven't abandoned my argument, but if we're gonna allow all the whole list of overt acts on the indictment to go back to the jury, I would ask.
Well, not the ones that y'all decided there's no evidence of.
Right, but the ones outside the statute of
Yeah.
limitations, I would ask that, on number 6, it's committed an overt act on or after May 10, 2017, or
True.
within the applicable statute of limitations.
True.
Yeah, the only thing I'd point out is you've got that later.
I do.
And so, I mean, I agree it has to be somewhere. The question is where.
Well,
Well-
I mean, the idea with listing out the elements is when they're deliberating, they can go right to that and go, all right, here's what we need to be thinking about. So,
Which is why I think Mr. Schart's suggested edit is useful.
so I had written down the dates. It's like between May
It would be May 10,
10th of 2017 and May 9th of 2022.
No, it would be within 5 years of the date of the indictment.
No, but let's
Right,
give them the dates.
why not just give them the date? Why make them do math?
Yeah.
All right.
Nobody wants to do math here, we're all lawyers.
The calendar in my head wasn't functioning properly.
Yeah, I mean, the indictment, the original indictment was what, May
May 9th.
9th? Okay, so,
If that captures that 5-year window, we have no argument.
okay,
But the indictment doesn't, the indictment says, said accused together with unindicted co-conspirators in the state of Georgia and county of Fulton. You mind if I said?
go ahead.
On or between the 24th day of January 2013 and the 8th day of May 2022. So maybe the cutoff
Okay.
date should be the 8th day
So
of May.
then May, what would that be? May,
May 8th, 2022.
no, for the beginning, May 9th,
Oh, it would be
2017?
May 9th, 2017.
actually May 10.
No,
Because
I do
the
too,
indictment
May
came out-
10th. I don't think they're,
Yeah, the indictment came out May 9th.
and May 8th, and honestly, the dates don't, and I'm saying May 9th, 2022.
Your Honor,
Yes,
the evidence demonstrates the conspiracy continuing after that. The evidence that's been admitted demonstrates the conspiracy continued after that. That's
so what's the law on, is it, within 5 years before the indictment, or is it within 5 years before the indictment?
It's before the indictment is what the cases say. I mean, if you look at, I believe it's Conzo,
But
that's the case. And
continuing on up until the jury gets the evidence.
yes.
Well, I would disagree with that just because it's specifically pled
Yeah.
in the indictment. It says, in the RICO charge, it says, for the said accused together with unindicted co-conspirators in the state of Georgia, County of Fulton, on or between 24th day of January 2013 and the 8th day of May 2020.
Yeah, and with that specific date in there, I would think that anything after the 8th day of May 2022 should not be considered.